So let's examine the hit and run statute in Louisiana. What is a hit and run? Hit and run driving is the intentional failure of the driver or vehicle involved in or causing an accident to stop such vehicle at the scene of the accident, to give his identity, and to render reasonable aid. So you got to stop at the scene of the accident, let the other driver know who you are or the police, and render reasonable aid if that's what's necessary. So what are the penalties? It is a misdemeanor as long as there's no death or serious bodily injury. So the defendant is looking at up to 6 months in jail, a $500 fine, or both. Whoever commits the crime of hit and run driving when there is no death or serious bodily injury shall be fined not more than $500 in prison for not less than 10 days, nor more than 6 months, or both, when there's evidence that the vehicle operator consumed alcohol or drugs, and that the consumption of that alcohol or drugs contributed to the accident, and the driver failed to stop, give his identity, or render aid with the knowledge that his actions could affect an actual or potential present, past, or future criminal investigation. Another scenario is whoever commits the crime of hit and run driving when death or serious bodily injury is a direct result of the accident, and where the driver knew or should have known that the death or serious bodily injury has occurred, shall be fined not more than $5,000 or in prison with without hard labor for not more than 10 years. So this is a felony. This is when the driver hits somebody and they knew or should have known that they killed a person, or commit or cause serious bodily injury, and they didn't stop, and that accident was a result of it. Then the final provision they have in the hit and run statute involves when the driver commits hit and run when the following conditions are met, and he's looking at 5 to 20 years on this one. So this is the roughest one here. So death or serious bodily injury is a direct result of the accident. The driver knew or must have known that the vehicle he was operating was involved in an accident, or that his operation of the vehicle was a direct cause of the accident. The driver had previously been convicted of any of the following. So if he's been convicted of a DWI or vehicular homicide, pretty much anything related to DWI and driving. So if you've been charged with a criminal charge, a hit and run, anything in Louisiana or Baton Rouge, feel free to give me a call or visit my website for more information. You can see this full statute.